It's me again. Okay, I was watching this. I didn't see this one until just now, but I was watching this and I was like, oh no, excuse me. I have so got to go live and show y'all this one. So this is funny. Now, she does have some guests come on. So, you know, I don't know their opinions. I don't know anything about those other channels. I don't really know who they are yet. So, but we're going to take a listen to this and get some laughs after that really tough case we just listened to a little bit earlier. So, let's get into this. This is going to be good.
Oh my gosh. Ever since the court date on August 22nd, y'all have been waiting for these transcripts to come out because to read it and to hear her, first of all, the entire time since then, she's just been nonstop lying about what happened and what didn't happen. And then to actually read the transcript of what exactly the judge said to her, what she said, what the lawyer said, it takes out any doubt of he said, she said, the stuff that she's claiming about the lawyer. It just squashes all of that. And I'm so here for that. So excited. Right. So I have two special guests today. And playing the judge is the Honorable Judge Toasty. And playing the lawyer is B. Tim. And playing Bullhorn Betty is the fabulous JP. How are you guys doing tonight?
I'm all right.
I'm good. How are you?
Cool. Okay, so before we get into the reading, I want to get caught up here. Dreams, welcome to the dumpster fire. I appreciate that. Whispers in the shadows, welcome to the dumpster fire. And Little Irish Girl, welcome to dumpster fire. Betty's Commission Grift, member for 17 months. I like your name. Monday Night Toast, thank you so much. And Darzilla, welcome to the dumpster fire. I really appreciate you guys being here. Okay, cool. Okay, so we're going to do the dramatic reading. And then afterwards, I'm going to have an open panel and we're going to discuss. And I think there were some other people that wanted to join and we're going to discuss what it is that we just read, which not what I don't think I did that last time. I don't remember if I did, but I was like, I probably should do that this time. Anyway.
Well, we did go through like 70 pages and JP's voice was about to die.
True. Yeah, this one is only 52 pages and two of them are like basically the front and back. So
yeah,
not nearly as long as last time.
All right.
Katie Joyless Unveiled, member for 3 months. Thank you so much. So excited. So am I. Okay, so we're going to get started here. Let's see if we can do this. I guess we could do that. I blew it up really, really big so everybody can see it. So I guess we will just jump right in. All right. Got to put my judge voice on. Pretend to be the guy that Betty thought I was back in January of 2022. In the Circuit Court of the 9th Judicial Court, Circuit, Knox County, Illinois, Andrew Griffin v. Queen Bee motion hearing on the 16th day of August 2024. Appearances, Andrew Griffin via Zoom and Jonathan Phillips, the attorney at law for Queen Bee, also via Zoom. The following report of proceedings was electronically recorded. The court. This is case number 23 LA16. It is Andra. I'm sorry. Andra Griffin is the plaintiff. Queen Bee is the defendant. And Miss Griffin's here representing herself. Mr. Phillips is here representing Queen Bee. There's somebody in the waiting room named blank. Who is that? Anybody know?
Probably. They're not supposed to be here.
You have no idea, Mr. Phillips?
I don't know who that is, Judge.
All right. Well, if they're not a party to the proceeding, I don't consider them a participant. And if they choose to be here today, they could be in the courtroom. So let's see, Miss Griffin, you filed a notion of hearing on a few different things, but here there are several different. There are a notice of hearing, an amended notice of hearing. So why don't you clarify for me?
Sure, yeah, because
Your understanding of what we're here for.
sure. So I made some scrivener's error on the original, and then Mr. Phillips acknowledged that I made some scrivener's error, and then I forgot to change the certificate of service. So the second amended notice of hearing is the one that we're going to be working from, and this is related to the plaintiff's motion to dismiss defendant's First Amendment. I mean amended counterclaims. We've got motion for accounting of earmarked funds and for those proceeds to be managed by the registry of the court. The plaintiff's motion to revoke and object to the issuance of defendant's subpoena to Google, and the motion to limit questions and scope of deposition of Andrew Griffin.
All right, that's what I printed out. Were those documents? And just before we get started, are we talking about the counterclaim that was filed?
This is a counterclaim that was, well, it's the first amended counterclaim that were filed by the defendant on November 8th, 2023.
On November 8th, okay.
Yes, sir.
All right, and then your motion to dismiss was filed December 6th, and then Mr. Phillips, your response was filed January 2nd, just so I'm clear on all that.
No, I believe our response was filed on December 29th of 2023. I think the issue is that the notice of hearing says complaint versus counterclaims.
No, I put counterclaims in here on the second amended notice of hearing.
Okay.
Well, you may have filed it. It does say the 29th, but apparently on the actual, I see up here on the actual file stamp, it does say December 29th.
Yeah.
But when I look at it in the registry here on the documents, it wasn't actually put in the docket until January 2nd. So I think we're talking about the same one.
Sounds like it, Judge.
Okay.
It sounds like the new year probably withheld it from being, yeah.
Yeah, I think so.
Yeah.
So Ms. Griffin, you set these for today. How about we just do them in the order that you listed them?
Yeah, well, we're going to be out of order just a little bit because I wanna put my plaintiff's motion to revoke objection before we do the motion for accounting and earmark funds. And there's a reason for that. And I just listed them wrong. So if that's okay with you, Your Honor.
Motion to revoke objection to the issuance of defendant's subpoena?
Yes, sir. I'd like to do the motion to dismiss first, and then the motion to revoke an objection, and then the earmarked funds, and then the limited questions, if possible.
Any objections to that, Mr. Phillips?
No, I don't care what order we go in, Judge.
All right. So motion to dismiss is first.
Yes, sir.
All right. And then so 2 and 3 are just out of sequence.
Yes, sir.
Okay. All right. Why don't you go ahead on your motion?
Sure.
To dismiss.
Sure. So we've already been before the court for these two arguments already, and I'm really just going because, to be honest with you, Your Honor, I think you're going to go ahead and allow the defamation to proceed. So we're just going to focus, for me, on the abusive process aspect of this argument. One of their arguments in this abusive process is that I did this. First of all, I've never had anybody bring a claim of abusive process in any court across the United States against me yet. That's their standing for bringing the abusive process to this court hearing, in that I done some horrible stuff at some other court in some other state at some other date and time years ago. And that's their standing for the abusive process in this case. However, things have changed since then, and we've been, going down my second amended complaint, and in the argument that was just filed by Mr. Phillips related to QB's motion to dismiss under section 2-615 code, the Code of Civil Procedure. He acknowledges that we have standing predominantly with sexual relation allegations, and in it, well, not subject to constructive, innocent construction or truth, which my sex life is not in innocent construction or truth. But either way you look at it, this is abuse. This abuse of process does not exist in this case. I have legitimate claims in this court against QB. Not only that, QB still hasn't ceased her behavior yet. She's still attacking me. She's still having her audience call law enforcement every place I go. This has not, it hasn't stopped. So this idea, that this illusion that they would like this court to believe that I do not have standing in this court is just ludicrous. There's overwhelming evidence to support my claim that this lady will not leave me alone. She's completely obsessed with me. Still to this day, a year later, will not leave me alone. I absolutely have standing in this court. I have absolute right to bring these actions and claims against QB. And so I think this abusive process is absolutely, there's no way they can have standing based on another court, another time. They can't even explain what I've done in this case to support these allegations. This is legally insufficient. They don't have standing to bring this, and they have not met their elements, Your Honor.
All right. Care to reply, Mr. Phillips?
Yes, Judge. First of all, I note that my response was filed, like I said, on December 29th of 2023. We're just now hearing this motion 8 months later. We believe that many of these filings are dilatory, include this one. That said, we believe that the abuse of process claim is well pleaded. I am not sure what Miss Griffin is arguing today because we haven't made a standing argument. There's no standing argument here. It's also clear based on her oral argument today that Miss Griffin is relying on things outside the four corners of the first amended complaint, which, as we know, is not proper for consideration in a motion to dismiss. The simple fact of the matter is that we have alleged and provided facts to support the elements of an abuse of process claim. We have alleged and provided facts for ulterior purpose and some of use for ulterior purpose and some act in the use of legal process, which is not proper in the regular prosecution to proceedings. And we cited to on page 4 of our response, Shelby versus Ordia for that. And Shelby also explains that intimidation can serve as a basis for abuse of process claim. And that is why when we plead our facts in this particular instance, we have pled facts involving Miss Griffin's prior behavior to demonstrate that what we are alleging specific to this case is part of an intimidation campaign. So we have alleged things in paragraph 42 through 45, 69, around 69 through 70, 72, 77, 80 through 86, and 91 through 92 that indicates the use of the court system to do things like that, what Miss Griffin has told reporters, quote, to drive people a little nuts. We have alleged that she has engaged in harassment of QB in other means, not necessarily through these proceedings, and use this case in particular to what the term is called doxing, which is to take someone who's acting anonymously on the internet and kind of dump their public or basically out who they are on the internet. A woman that went by Heels of the Air or Heels in the Air, who I believe is now deceased, but she was sued in this court as well. But as we use those facts to establish that when the act of process here was the act of serving QB through the Knox County Sheriff's Department, and we've alleged that in paragraph 93 through 96, someone was filming that service. And it was either, upon information and belief, either uploaded by Miss Griffin or caused by uploaded by Griffin, and then was removed despite an evidence preservation demand. And now, no doubt, Miss Griffin may disagree that she had anything to do with it, that it didn't occur, what have you. But the idea of having someone serve at their residence and videotaping it is not part of the and then putting it on the internet is not part of the regular traditional process. And again, we believe and we've alleged that it's part of the intimidation tactic. If she says she didn't have anything to do with it, that's fine. She can deny that allegation. If she doesn't think that it's intimidation, that's fine. She can deny that allegation. If she simply doesn't know what's going on or why we're alleging it, she can say, I'm without sufficient information or knowledge to admit or deny these allegations. But the simple fact is these allegations do, in fact, provide the basis for the first element of an abusive process claim. And since Miss Griffin has went outside the four corners of the complaint or the counterclaim, we've also note that the process is now again being abused by this motion to earmark funds. Process here.
What we're not there yet. We're not here for that yet.
Process here, Judge, is not just the service of process like it is with a sheriff process, as the law defines it. It is any time that someone asks this court to exercise its authority on someone, which would include this earmarked funds. So in the event that the court is inclined to dismiss the First Amendment counterclaim, we would, of course, ask for leave to replead because we now have more facts that show attempts to abuse the process. We believe that the two elements under Selby versus Odia are met through those paragraphs I referenced, which are also referenced in the response as well. As to the defamation per se, I know that Miss Griffin just didn't argue it now other than to say that she admits that the defamation per se will probably survive, and that's probably because our position that even filing the motion as it relates to defamation per se was frivolous. 10 months ago, on October 2nd, 2023, the court already agreed that the defamation per se survived and stated, quote, Griffin will answer for the scheduling order. Not Griffin can move to dismiss it again. Griffin will answer. Instead, she's moved to dismiss the same filing, the same count that was not modified in any substantial way, and we didn't modify it in any substantial way for just that. But that said, since it has been alleged again, we now have to argue it again. Unless Miss Griffin, I didn't hear her withdraw the motion as to that. She simply said she expects to lose it. The full statement about that the plaintiff made an unprivileged publication, the publication caused damage, that Green versus Rogers on page 6 of our First Amendment counterclaim, we have alleged Griffin accused QB of selling drugs to children. That is a crime. We allege that it is false. We allege that she published it to a third parties via YouTube, over 10,000 people. And I believe it was around 11,000. And because accusing someone falsely of a crime is defamatory per se, damages are assumed. Therefore, we believe that the defamation per se is well pleaded, just like it was well pleaded almost a year ago, and the court already believed it was. Otherwise, in her motion, she mentions that she wanted verbal statements to be attached under the Rule 2-6 or Section 2-606 of the Code of Civil Procedure. Again, that argument was already rejected by the court. The court in the last hearing, quote, stated, quote, if it's a verbal statement, how could they attach anything, end quote. And that was Exhibit 1 to our response. Yeah, you can't attach a verbal statement. So that's not a basis to dismiss the complaint, either or the Sorry, the First Amendment counterclaim. Otherwise, something that Miss Griffin kind of hinted on was her portion of the motion that was sort of a motion to strike, claiming that allegations were irrelevant. But as we explained above, well, first of all, I just know Miss Griffin's filings are quite voluminous, so she plainly understands the need to provide some degree of context. Here in Illinois, we have to engage in fact pleading, not notice pleading, and sometimes to explain or to give a flavor, if you will, to why a particular fact supports something, we have to explain why. We have to give some other facts for that. And that's really what we've done. We don't believe that any of these allegations are relevant. Our First Amendment counterclaim is not overly lengthy. Again, it's easy enough for her to simply decide to admit, deny, or I don't know what you're talking about. So I can admit or deny. And then finally, in the response, we note that some of these arguments have already been not only explicitly rejected by the court previously, but the court explained on the record why they are being rejected. Yet they were brought once again, and my client shouldn't have to pay me to re-argue things that the court's already rejected and are just being brought again, not in the form of a motion for reconsideration or anything like that, simply grinding out legal fees. Thank you, Judge.
So let me get this. Let me just be clear that the second amended or the amended counterclaim is the result of the amended initial complaint. Is that right?
She's now on her second amended complaint.
Right.
But yes, when we had our last hearing, at that point, the court, and I can't remember if it was Your Honor or Judge Rasmussen, to be honest, but basically everyone was repleading everything.
Okay.
Is what it amounted to.
All right.
But when I took the defamation claim that he allowed and said she answer it, I just plopped it right back in.
Okay.
Didn't really change it.
Okay, I just wanted to be clear that the procedure that was Rasmussen, I'm sure if it was in 23.
Okay.
Okay, Miss Griffin, you have a response?
Yes. He's brought up a lot of different things here. First of all, again, this is the first I'm hearing that somebody was recorded upon service. I didn't even know the lady was going to be served. So that's we're not going to argue evidentiary matters in this. The abusive process, according to Illinois, takes a very high level for the courts to bring an abusive process. There has to be overwhelming, substantial information there, and this is not. They're basically referring to another case as they're standing here, and I'm sorry, but there's nothing that rises to the level of abusive process in this matter from the beginning from the onset of this very original complaint. I'm trying to get something stopped. I'm trying to get this to stop. I'm trying to get the damages to stop. And every time I turn around, Mr. Phillips and his client are doing damage to me. But getting back to the four corners of this, I don't understand how they can sit there on one hand and say I have potential claims, and on the other hand say I'm abusing the process. It doesn't make sense. But there's a heightened level for this to be argued in order for the courts to allow in the abusive process. And I don't think that they've met that bar. I don't think they've met that bar. He brought about doxing. They will have to prove that I was the first person. I'm a web sleuth. That means unless something is out there in the web, I wouldn't be privy to it. That means that somebody else has had to dox QB in order for me to know her name. If he's going to be talking about the doxing, he's talking about the first element of this abusive process. But I do not believe he has met any element of this abusive process. And talking about service, I have to serve documents to him, and now apparently service of of process is abusive process, according to Mr. Phillips. Furthermore, he had a complaint that he could have moved forward, and I was supposed to answer. He chose to modify, making a first amended complaint, effectively giving me a second bite of the apple to argue. He did amend his complaint. The courts cannot bar me from dismissing an amended complaint. I've never heard of such a thing.
All right. Anything else, Miss Griffin? Sorry, I didn't mean to cut you off.
No, this is just, it is what it is. But there's no elements. There's no cause of action here for the abusive process, Your Honor. And the courts have a heightened level of this abusive process in order for it to go. And I don't think he's met that heightened level.
All right. So on the motion to dismiss the amended counterclaim, that one I'm going to take under advisement. I want to read and reread the counterclaim and the motion and the response. So I will take that under advisement. I don't keep cases under advisement very long, so I'll get a decision out that one pretty quickly.
I appreciate it.
So then, Ms. Griffin, let's move on to, you wanted to do the motion to revoke?
Yes, sir.
An objection. Okay.
Well, this is a clear abusive process right here. Mr. Phillips now, mind you, I have no idea. I did look into allegations. I did find out QB was going around and hitting a lot of people that were putting information out that was going to help this case. And so she started hitting all of these other content creators with improper copyright claims to have their stuff removed. Apparently, one of those people she hit, I don't know who it is, allegedly used Mr. Phillips' name and information on it. He reached out to me and basically told me the situation. Now, mind you, he never accused me of doing it. On QB's Twitter page, I quote, on March 10th, she says, at Team YouTube, this channel is impersonating my attorney. This is not only illegal, but against terms of service. Please look into this ASAP. Attorney is taking the legal route, but this channel has violated terms of service and needs to be removed for impersonation policy. And it's citing a YouTube, in their own words, as the person she's accusing of impersonating her attorney. Her attorney knew about this. Her attorney was well aware that she was accusing somebody else. Yet this particular subpoena shows up in our court. He basically hijacked these proceedings to go on a fishing expedition for his own personal benefit and his own personal thing, unrelated to this case, with people that haven't even been brought up of this. This right here, he knew was improper. Did it anyways. I asked him to remove it. I asked him to withdraw it. He basically laughed at me in email, saying there's nothing I can do about it. So I did a motion to revoke an objection because this is highly improper, and he knew that. He continued to go down this road. Oops. He knows that this has nothing to do with me, yet he's hijacking these proceedings to go on a fishing expedition for another content creator.
Okay, and that's the motion you filed on March 15th of 24?
Let me just see what this March 15th, 2024. Yes, sir.
Yeah.
Your Honor.
Okay, all right. Mr. Phillips?
A couple of preliminary things. Then I'll think it will be taken care of pretty quickly. Number one, Miss Griffin turned this into an evidentiary hearing. We specifically requested for this hearing to take place in person because of these very types of concerns. Yet it wasn't, and she's reading from Twitter. I don't know what she's reading from. It's now suddenly an evidentiary hearing based on whatever she has to say. And we believe it should have been held in person. Another reason these hearings should be held in person is the court can see the vitriol, and ad hominem attacks that Miss Griffin's engaging in. It's another reason under local rule 2.80E that we believe that future hearings should be held in person if they're contested. That said, the court will note that we didn't file a response. We didn't file a response because Google already complied with the motion, with the subpoena. The motion is moot, and it's essentially a motion to quash. The matter's moot. There's already complied the end. So there's not really.
It isn't Miss Griffin or anything to do with this case. No.
Go ahead, Mr. Phillips. Miss Griffin, you'll get a chance to respond.
Yes, sir.
Again, it's moot. So there's not really much more to say to that. But insofar as Miss Griffin is suggestion that I'm acting improperly, not my clients. And again, this is par for the course in this case. The simple fact of the matter is that this is a case about unrestrained amounts of harassment, abuse of the legal process, and otherwise by Miss Griffin. We have the right to conduct discovery on anything that is likely to, not even likely, that is reasonably calculated to result in finding admissible evidence. If Miss Griffin had nothing to do with it, great. We won't find anything. But we're allowed to check why someone in the midst of this litigation is using my name, i.e. QB's attorney, to submit DMCA takedown notices, especially when that, for obvious reasons, judge, can be used to harass QB in this case. Make her think that their attorney is acting against her interests when we have other motions in this that are being heard today that would also require me to act against my client's interest by somehow becoming a steward of her assets. The simple facts of the matter is this isn't a fishing expedition. This is a highly suspicious. We have the right to conduct discovery on anything that is reasonable calculated to lead to admissible evidence. I personally believed it was reasonable calculated to lead to admissible evidence, and we intend to track down who was posting it. If it's associated with Miss Griffin or it is Miss Griffin, then it's relevant. If it is not associated with Miss Griffin or is not Miss Griffin, then it's not. And then that little discovery process ends. But it's just discovery. That's all it is.
He hijacked this court hearing, Your Honor. He hijacked this court hearing for his own personal vendetta against his name for another content creator that he knew had nothing to do with me. And he laughed at me in emails. He said he's going to get this through, and he did. And I guarantee it had nothing to do with me because he didn't even accuse me. No, nor did his client. They use this for a fishing expedition. This is highly inappropriate, and he knew better.
If I may, Judge, the reason I didn't accuse Miss Griffin of anything is because I don't engage in ad hominem attacks. Like we're just doing discovery, and that's all, Judge.
The only discovery so far, brain.
All right. So I don't have a copy of the subpoena that was sent. I don't believe it wasn't attached to the motion, and it obviously when a subpoena gets sent out, all that gets sent out is a notion of the subpoena. And so, Ms. Griffin, I don't have enough information to determine whether or not it's appropriate or inappropriate. And again, Mr. Phillips is partially correct. Discovery by nature is a little bit of a fishing expedition to determine if there's relevant or non-relevant information. So I'm denying that motion to revoke and the objection to the subpoena. Now, if it turns out,
and what's the
later that there's some information in that subpoena that was improperly obtained, then we deal with that later. But I'm denying that motion.
Yeah, well, there's not going to be anything in there because it has nothing to do with me.
Okay.
And he knew that.
So let's.
I assume that came. I'd like to know that if he's suing the people from hijacking my case, but either way.
All right. So let's move on to the motion for the accounting of earmarked funds.
Sure. So, Your Honor, this is a situation where QB has been collecting funds under my name, basically saying that this is for these court proceedings. She's raised over $20,000 for depositions. She's raised over $20,000 for the counterclaim. She's continuing to raise funds using my name and these court proceedings as a money grab. I have claims of unjust enrichment in the courts. In the complaint currently, the second amended complaint, I have the conspiracy arguments as well as the intentional infliction of emotional distress arguments, as well as the second amended complaint. And so I'm making claim to some of these funds. I also am stating, she has raised these funds for a specific purpose. This is not a slush fund for her to be able to pay people to harass me or to follow me or anything like that. These are funds for this court for very specific things, such as depositions, the counterclaims, and she keeps raising more and more and more and more funds. And somebody needs to know where all this money is going. Where's all this money going? It's for the benefit of this court hearing. It specifically identifies this proceeding as the reasons for identifying and collecting this. These funds, but she can just take all this money under these fraudulent circumstances and use them any way she wants to. These are specific. They every single response QB files on Mr. Phillips files on QB's behalf is demanding me to pay fees that she's not even paying. She's got a $70,000+ slush fund that she keeps adding to for this court case, and somebody needs to find out how much money she's collecting or what. Make sure that these funds are being utilized for this court hearing. I don't want to know about any type of contract she has with Mr. Phillips. I don't want to know what the terms are. I don't really care how much he's charging her. I mean, he's got a $70,000 slush fund here, but I do want to make sure that these funds are being utilized for the court hearing. That's what they were raised to do. This is in the court's discretion. Mr. Phillips is arguing that this is so inappropriate. That I don't know why we have a registry of the court or escrow accounts for attorneys, since this is so bizarre to even ask to, make sure that this is safe, kept for the proceedings here to make sure that she has the money for the depositions, the counterclaim, which she's already, I don't know. I don't know if this counterclaim cost her $20,000, but she's definitely collected $20,000 just for the counterclaims alone. I'm very, very curious, what's going on with these funds? And if I'm going to be on the hook for paying them back, then I'd like to know, how much is being spent. There's a slush fund here. She hasn't paid one dime. Meanwhile, I have lost money because of her attacks on my channel, her shutting my channel down. I've had to come to court in person, which cost me over $1,000. The only person that isn't spending money right now is Mr. Phillips and his client. I've lost thousands of dollars, tens of thousands of dollars, and she's collecting tens of thousands of dollars to attack me even more. And I don't even know if these funds are being used to harass me, which every place I go, she's stalking me. She won't. If I go live from a hotel room, she's literally going through Expedia to find out what hotel I'm in. She just did this not even a week ago. I need this stuff to stop. And I don't know if she's using this money to put me under surveillance or to have people constantly running around looking for me. I want to make sure that these fees are for this court action and this court action alone, which is what they were raised to do. And it's within the court's discretion. No different than disputes over a number of things that the registry of the court is used for.
Okay, thank you. Mr. Phillips?
Yet again, we have a series of evidentiary matters on a non-in-person proceedings, despite Ms. Griffin saying it wasn't evidentiary. She starts off in her oral argument by saying, my client raised $70,000. I don't know what that it's 70,000, but then Miss Griffin goes on to say, well, we need to do this because we need to figure out how much has been raised. Is it 70,000 or is it none? But either way, we also then end up with more evidentiary issues in this non-evidentiary hearing when things like they're being brought up, like she's lost tens of thousands of dollars, that my client's undertaken certain actions or not undertaken certain actions, but all she wants to use all this in support of this motion. Yet it's not an evidentiary hearing. It's not occurring in person. The simple fact of the matter is, Miss Griffin has, if she has lost tens of thousands of dollars due to this lawsuit, she chose to file a lawsuit. I don't know, 1,000 miles away from wherever she lives. The simple fact she asks is a registry, interpleader actions, easy answer. Why is there an escrow account? Why do I have an escrow account? I am assuming she means an IOLTA or account. Interest on a lawyer's trust accounting? Well, there's 3 reasons for that, as lawyers know. There are security retainers. There are local. That's the only one I use. But there's the one for the criminal cases. There's one where, you have an escrow account for closing deals and so on and so forth. Again, those are all technically an IOLTA account isn't my account, but it's my client's account. I don't even get to control that. So when she asks, why is there a registry? Why is there an escrow? That's why. It has nothing to do with earmarking funds. Here, simply put, we believe the quest is incredible because it attempts to force this court to appropriate Turner's property and turn to interfere with the attorney-client privilege and force me to work for Miss Griffin. It's not surprise then that there's not a single iota of any authority, statute, nor no case, no rule, nothing in her motion. More technically, and just to make it easy, Griffin lacks standing. She doesn't actually have an interest in the funds. She didn't, as far as we know, provide any of these funds. Maybe she donated to the cause, if you will, but I don't think she did. She didn't mention she did, and it's not an evidentiary hearing, so we do not know. But lacking an interest in the funds, she lacks standing, which we have pointed out in our motion, in our response, that is standing is necessary here. She simply doesn't have any. We believe this is another dilatory tactic. The relief simply can't be granted. She lacks standing for this court to appropriate whenever money has been raised by QB to defend this action. And as far as the idea that she can get my client, force me into holding my client's money under all the regulations promulgated under IOLTA and the rules of the Supreme Court and the Illinois Attorney Regulatory Disciplinary Commission concerning how I then have to do counting essentially because Miss Griffin wants me to do it. She shouldn't be allowed to do that. And frankly, she's not cited to any authority, any rule, nothing in her motion. And having failed to do so, she has essentially waives her arguments by not developing them. Thank you.
Miss Griffin, do you have a response?
I totally disagree. I think this is within the judge's discretion. I think this is within the court's discretion to do. It's been done before. It's not like it hasn't. This woman has raised a lot of money. She's continuing to do so. He keeps saying this is an evidentiary hearing. Apparently, every time I talk, it must be evidence coming out of my mouth because this is not an evidentiary hearing. I haven't presented anything to this court as evidence. I have spoken about it. And I do believe that there is law that supports my standing in this, in the motion for the accounting.
All right.
If I may briefly, Judge.
Go ahead.
If Miss Griffin is now stating that now none of this is evidence, then we would also ask that it be denied because she hasn't established that my client actually raised any money.
Okay. Well, Miss Griffin, I do not believe the court has the authority to require that funds be earmarked that maybe maybe again has required through donations of people. I'm not sure, but there's very few cases where the court will take funds into the court registry, as you say. One of those, and that would be with the circuit court office, that would be an interpleader action. There might be some other kinds of actions like that, but this is none of them. And
Okay.
so I'm going to deny that motion as well.
And will you at least take notice that there's been a substantial amount of funds collected for this matter?
Well, I don't know that. I mean, you say that in the pleadings, but again, I haven't heard any evidence in that regard. So moving on then to your motion to limit questions and the scope of the deposition of yourself, go ahead.
That's correct. So as you know, and as clearly defined inside the pleading, unless he's going to argue that this is evidentiary as well, this network of people headed by his client have been hell-bent, excuse my language, on destroying me professionally, publicly, and this is no different. They're using the transcripts of this court. I don't even know if they're ordering the transcripts of the court. I guess I'm gonna have to look into that, or if QB is giving them the transcripts of the court to run these stories with. But she's got a network of people that are utilizing this court to attack me, and so she brought up arguments, or she brought up things like, which we know is part of my second amended complaint, that she has stated on the record and in front of people, all this person that I'm apparently having sexual relations with. She said it to thousands, tens of thousands of people on like 3 or 4 different videos. One that had an animated video of me allegedly engaging in this sexual relations. I'm a private person. I don't know QB. And how does she, and I know that they're going to be focusing a lot of their deposition questions on things that are going to embarrass me, or things that are going to be ultimately turned around into content for QB and her friends. I'm here trying to protect myself, protect my interests. She has no business being in my bedroom. She has no business being in my personal life. She does not know me, and I know for a fact that he is going to. I tried to stipulate with this man, and he wouldn't. This attorney, and he will not stipulate to have off-limit questions. And I'm sorry, my sex life should not be for the public domain. It should just not be. And this is part of the claim. She should have never brought it up, let alone making animated videos of it. And now she wants to investigate it. This is preposterous. This is my personal, private life that I did not ask this lady to talk about on her channel. And now they want to come in here and talk about personal stuff that will absolutely be put on QB or her friends' channels. And I'm trying to protect myself here. I would not be in this court tens of thousands or thousands of miles away from my home going through all this if I wasn't here before the court to protect myself, protect my interests, and to stop the damage that this lady is going to do to me.
So one of your allegations in your defamation claim is that you're alleging that Queen Bee has stated that you were having sex with somebody.
Basically, yes.
Correct?
Well, not basically, but.
So.
Oh, that's exactly what she said.
Right. So do you then feel that it's improper for in a discovery deposition for someone to ask you questions about the truth or the falsity of that?
Because she didn't. She doesn't know it. Why? If she was going to say it on her channel, it should have been true, and should have had information to substantiate her claims. now trying to sit here and depose me to see if she has any standing with that claim or anything like it is ridiculous. She either had it at the time or she did not.
And she doesn't. You're saying she's not entitled to ask you that question?
She can. I don't think that these. I mean, if she wants to ask me those questions in a very limited capacity, I'm fine with it. But to divulge, for me to have to go through my entire sex life, Your Honor, is a little crazy. I didn't bring this upon me.
Well,
I didn't ask for this to happen.
I'm not talking about your entire sex life. I'm talking about the allegation that you made against her, saying that she's accusing you of having sex with a certain individual.
I understand, and I want that limited. I want it to be based just on if that's what the issue is, and they have evidence upon that, which there's nothing there. I don't mind that, but I don't think it's just going to stop there, Your Honor.
Okay.
I really don't.
Well,
They're out to embarrass me and humiliate me at all costs.
I just wanted to be clear what you were saying there.
Right.
Because when you raise an issue, them asking you about that issue is fair game.
Right. And I'm
But them going
I'm perfectly capable of answering
beyond the bounds of what's reasonable, even in discovery, is not fair game.
right.
And so I just wanted to be clear what you're asking about, okay?
Yeah, I know what they're gonna ask me about, which I don't even know why it was a topic of discussion on our channel, because I mean let's face it, whether I'm banging the whole entire football team out there, it doesn't matter. It's not for public consumption. It's my private life. She doesn't know me. She's never been around me. She definitely doesn't know my personal information, yet she's acting like she does. And spreading this, so whenever I do bring a claim, it's got to be explored.
All right. I'm just trying to narrow down what your actual objection is.
Yeah, that's
Okay.
it.
All right.
I just want it very limited. If they're going to ask me, I think it needs to be limited, Your Honor. I think that I brought enough to this court to show you and to show this court whether it obviously a lot of stuff needs to have evidentiary findings on it. I get that. But at the end of the day, I've raised enough. I even put enough information within this to show what they've been doing to me. How her and her friends are utilizing this court action to further damage me. So it's intimidation, first and foremost. They're intimidating my witnesses. But we're not even going to go into that. I just want to limit what can be asked of me with respect to that allegation. I don't want it going on a fishing expedition. I don't need any more nonsense splattered across his client's YouTube channel or her friends that she conspires with.
All right. Anything else?
No, I think that's it, Your Honor. I appreciate you taking the time and, listening and
Okay.
to me, but
All right.
this is very upsetting for me.
I understand your concerns.
Yes.
Let me have Mr. Phillips respond.
Again, to start off with, we now have more evidence, something about animated videos in an evidentiary. Like, as far as I know, my client didn't make any animated videos. I believe those are made by a third party, but now we are again relying on evidentiary issues in this on the non-in-person evidentiary hearing. I think the judge, or Your Honor, kind of narrowed down the main part of things, which is Miss Griffin chose to sue. She filed a lawsuit about allegations that my client has referenced her sexual conduct. So yes, we're probably going to have to do discovery on Miss Griffin's sexual conduct to some degree within the bounds of what can be deposed and what is subject to discovery. Litigation is open to the public. That's a Supreme Court case, Nixon versus Warner Communications. If Griffin Griffin didn't want things to be open to the public, she should have
kept my mouth shut.
Opted.
All right.
Should have opted for blah, 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 dispute of resolution. Proceedings are public, not private property. Again, another Supreme Court case. Frankly, the public, the taxpayers of Illinois and Knox County are subsidizing Miss Griffin's hostilities towards QB. And the public has a right to see what they're paying for if she's concerned about things getting made public. If she doesn't want anything made public, there are mechanisms to do so. I can't represent her. I can't give her legal advice, but there are mechanisms to do so. She's not apprised herself of any of those mechanisms. Also, this is a discovery motion. There was no 201K consultation whatsoever. There was no ask. There was simply just don't ask about my sex life. But again, she's made her sex life part of this case. So again, there was no 201K consultation. That alone is grounds to deny the relief resort. The second is something that Your Honor, I think, tried to narrow down. I don't actually know what the relief sort on the basis of the written motion is. It's very just don't ask me some questions that I don't want to answer later on. There's no specific questions, no bounds. Miss Griffin isn't an attorney. If we're having a deposition and she just starts refusing to answer questions, then I'm going to continue the deposition. Then it will be adjourned. Then we'll have to go to the court to ask, okay, well, what are the questions like of these ones that she refused to answer? Then we're going to have another deposition. She's going to say, well, I don't have time for that. I don't want to come back to Illinois for that and anything like that. So we're going to have that issue. So we think it's improper to say, Mr. Phillips, limit your questions when I don't know, for example, she has apparently told police officers and or sheriff's deputies that she was in fact in a relationship with one of the people she says that she wasn't having sexual relations with. If I start going down that pathway and then she suddenly starts saying that's not what the case is about, stops answering it, it's just more delay. This case is old. We haven't even started discovery. I tried starting discovery at one point. She objected to it. And Judge Musid said, you know what? Let's wait until the pleadings are set. She's taken 8 months to notice up things after motions to dismiss are being filed. This case will never get to discovery. It's more dilatory tactics. And again, pages, and I just to point it out, and Your Honor already has it, but just so it's on the record, the second amended complaint, page 24 to 26, where she made this case about her sex life. Thank you.
Miss Griffin, do you want to respond?
Yeah. First of all, I know that Mr. Phillips likes to confuse things, but I thought this was noticed up when I was appearing in person. If you recall, I think it was the one that I appeared in person, and then we found out that I didn't notice it up right. So it's not like this was intentional. This is clearly a mistake. He had trial. He had another deposition at the end of July, making the soonest, because I was going to be out of town at the end of July in the first week of August for, again, his client likes to call cops on me, and he's acting like I just delay. We thought this was that I had properly noticed this up, and we were before Your Honor, and Your Honor, if you recall, we were like, I wasn't prepared for this. It wasn't properly noticed. So there were some mistakes that did happen that I own. It was obviously my fault unintentionally. So those are the reasons why we have the delay. It's not intentional delay or it's not intentional. He's trying to make it into like I intentionally did this for the purpose of the delay. And that's untrue. And so at the end of the day, I do think that there should be some limitations on it. And he's absolutely right. If I feel like he's prying in situations that don't, there maybe have to be, and you know what? If I have to come in for an evidentiary hearing, then that's what I have to do. But at the end of the day, I think that some of these things are, he's going to push the envelope, and I can tell he's going to push the envelope. just by the way he's treated me since the onset of this case.
All right. So, Miss Griffin, I understand your concern is on the deposition,
Uh-huh.
but your motion wants me to forecast what Mr. Phillips might ask, which I really can't do. If in fact there's a deposition, and if in fact Mr. Phillips asked you questions that you believe is outside the bounds of reasonable discovery, then you would refuse to answer that.
Right.
And ultimately, what would happen is Mr. Phillips might take some objection for the record. He may go on with other questions. You may refuse to answer some. You may answer some. You may refuse to answer other questions. But what happens in the end is Mr. Phillips then has the option. If you refuse to answer question, he has the option to determine whether or not it's worth his while to come to court and seek a remedy that you may be required to answer certain questions.
Uh-huh.
So the ball would be in his court at that point to pursue having those questions answered. And at that point, if he does do that because he thinks it's worthwhile to do, then that would be get presented to me. You'd have an opportunity to argue whether or not that question was reasonable, whether or not that was in the bounds of discovery, and whether or not your refusal to answer was reasonable or unreasonable. And so I understand that what your concern is. But again, I think it's premature because it's asking me to forecast things that I don't know are going to happen. So, and it requires Mr. Phillips to then pursue that as well, but so I can't.
Oh, well, is there any way we could seal some of this stuff to keep it out of the public's
Well, that
light until...
again, that's a motion that can be made at a later time, and that we'd have to talk about that. But initially, a deposition transcript is not placed in the court file. That is something done outside of court. It's not like a court transcript that could be placed in the court file today.
I understand that.
The deposition occurs outside.
But they're going to use it as soon as this deposition is over, and I need to seal some of this information. You know, it's...
And I understand that.
It's haunting me.
And so what you're talking about. But again, for me today, grant some kind of motion to limit the discovery questions. It really doesn't happen that way. It happens the way I've described. And so I think your motion at this point would be premature, I guess, for lack of a better term. So there's nothing that I can grant at this point. You have to have the issue first arise before I can make any ruling on what's appropriate.
Oh, well, by that time, it's too late.
And that's not appropriate. And
Gotcha.
And I'm sorry. And what's not appropriate?
Gotcha.
All right. So for the record, I'll show that motion denied. And again, I'm going to take the other motion to dismiss and basically you're talking about the abusive process claim, correct, Ms. Griffin?
Correct.
On the motion to dismiss.
It's ridiculous.
Okay, so let's move on then. We had a CMC that was the other day. It looks like I've got this matter under advisement. It looks also like there's been a motion to dismiss is it the Second Amendment complaint?
Yes.
And I don't know.
We need a hearing date on that.
Ms. Griffin, if you filed a response to that?
I'm sorry?
Have you filed a response to Mr. Phillips' motion to dismiss the Second Amended complaint?
I'm pretty sure I have. I'll have to go back and look and...
Well, let me take a look here.
I'm pretty sure I responded to just about everything but this wasn't noticed up for today.
No, it wasn't noticed up.
Okay.
I'm just trying to...
I wasn't prepared to argue.
I'm trying to do a roadmap of where we're going. No, we're not arguing.
Okay.
If I may, I'm sorry.
If I may, Judge, Ms. Griffin's response was filed on July 22nd.
Yeah, I see that. So that's still sitting out there. I've got the counterclaim issue that I have under advisement, so I'm just talking about what's still out there in the context of a case management conference. It seems like
If I
we ought to set that out until maybe November and see if we can.
If I may, Judge, I think we have that. And then also, Ms. Griffin, is for the CMC, I have noted that we needed a hearing date on the motion on the one that you were just talking about.
Oh, okay.
I believe it's.
I don't have. Well, let me see if I can pull up my calendar and give you a date.
If not, we'll certainly coordinate. The other thing that we had, Judge, was that Ms. Griffin filed a motion for protective order, like.
Yeah, he wants me to come into town. So let's go ahead and let's get that evidentiary hearing set for that. Mr. Phillips, when would you like to do that?
Well, tell you what, why don't you guys, rather than me sit here and go through the calendar, because chances are pretty good I won't get that right going through the calendar because other people do the calendaring. Why don't you coordinate whatever motions are outstanding with Carrie, and one or both of you, depending on whose motion it is, do notice of hearing. And my request on notice of hearing are that you specifically delineate which motion you're talking about so that I'm not
Okay.
sifting through the file to determine that's what's outstanding. So I'm going to ask that you coordinate those things, get those things set. Let's try to get those set before the next case management conference. So hopefully at the next case management conference, all of those things can be at least decided.
Yes, Your Honor.
I know October is a jury month for me, so realistically, that's probably not going to work out well. It seems like November 12th would be better case management date for me. Do you prefer 9:30, 10, 10:30, 11?
I'm a morning person, so I mean, I'm under the weather. And I was still up at 5 o'clock this morning.
Mr. Phillips?
No preference, Judge, and that day is completely available for me.
All right, let's make it 10 a.m. And it's just a very simple order, just basically kicking the case management out to November 12th. And I'll just say pending motions to be set and heard prior to the case management.
Is this an order you'd like me to draft up for Your Honor?
Well,
and then submit.
In the case managements, we just use a quick short form order.
Okay.
We can email this to one of you.
Email it to me, because I'm the only one that doesn't get the orders.
All right, but I need you to e-file it then.
Yes.
Okay.
I did it the last time.
I will email this to you. You e-file this order setting the next case management, just saying set for, get the order motion set for hearing. And then Mr. Phillips, can you pick it up off the e-filing system?
I'll pull it off the portal.
Okay, anything else?
Thank you, Your Honor.
For court today? Thank you.
Yes, sir.
Thank you, Judge.
Thank you.
All right, goodbye. End of proceedings. Wow. Oh my goodness. There was so many things that she said in that.
Yeah, there was a lot. That was a lot.
That was a lot. That was significant amounts of things that she said. I think she, not shocking that all of her stuff was denied. I think the abusive process was denied because her case was dismissed or something like that. So I guess he can refile. That's my understanding, I think.
Yeah, he can refile, but apparently in that state, regardless of how wild the other person is acting, apparently it's next to impossible to get abusive process in that state. So they were assuming it was going to be denied, but I mean, they needed to try at least, because in my opinion, this is 100% abusive process.
I mean, and the thing what Betty doesn't realize is if she goes to the deposition and she's like, not answering, he's just going to mark it for a ruling. And then he's going to go to the judge, and you're going to have to deal with going in front of the judge and arguing why you're not answering those questions. And then you're going to be forced to, he's going to say, you're going to answer this question. And then he's going to schedule up another deposition, and you're going to have to show up in person again to answer those questions. And if you continue it, then you're probably he's going to try to rule that you pay for the court reporting hearing, the court reporter. he's probably going to make a ruling for that if you force him to do you again. Like if you keep on like wasting his money with the depositions.
Yeah, and it's just. I'm sorry. Go ahead.
She knows that she has to pay for these depositions, right?
She's
Like-
going to have to pay for the deposition for Queen and any other witnesses that she brings forward.
Right. And I don't think that she realizes that. Like, she's the one that has to pay for that because she's the one that started this lawsuit to begin with.
Yeah, and the problem is that I think like she needs an attorney to question. I think to question Queen. I think so. I don't think that's a good idea. I think she's in big trouble.
Yeah.
I think it's probably for a Queen's deposition, it's probably going to cost her lots and lots of money, and she doesn't realize that like the costs are coming in now. She's going to have to come back to Illinois. I think she'll probably have to come back to Illinois multiple days.
Because, multiple, yeah.
Yeah, I mean, like I would say for Queen Bee's, for her deposition, she'll probably have to come back twice for 2 days because she's going to deny answering any questions, and then there's going to be rulings, and she's going to have to come back again. Then she's going to have to come back again for QB's deposition, which probably is going to be, if she's lucky, done in a day, if not 2 days, because then she's going to have to go to the judge if Queen, if there's like objections or arguments. Then she's going to have to come back for any non-party witnesses. Depends on the non-party witness, like that's going to come down. She's going to have to pay for half of that. She has to order her own copy for non-party witnesses. So yeah, she's going to be in a pickle of cost, and she doesn't quite understand. Like as soon as this starts going down, it's not going to be fun for her.
A couple of things. Senrise, did I say that right? Sen in the chat. You don't have to be quiet. Somebody accidentally did it by accident. They accidentally deleted your comment. You're not in trouble. It's fine. It's fine. And let me just get caught up really quick here. Let's see. Hope for Snoopy, member for 18 months. Thank you so much. I appreciate that. I'm a seahorse. Welcome to the dumpster fire. I appreciate it. Katie Joyless unveiled. So excited. Thank you. I'm excited that you're here. I'm a seahorse. Gifted a membership. Thank you. Mama of 8. Sense of super. Please quiet. I bet they put a sign on the door. Rachel Beth Huff. Thank you so much. Bravo. Appreciate that.
I can't believe she used the word slush fund. I mean, like, why would you ever put that in a legal proceeding? Because like slush fund means illicit activities. Like this is an illicit activity that she's got on the sidelines, and the lawyer is got this slush fund. And it's like, what are you doing, lady? Like,
yeah, I don't think that she understands what words mean. Like the other day, she was using proclivities, like sexual proclivities, and she was using that to describe someone who is a chomo. And I was like, no, you don't. That is not how you're supposed to use that word. But she was just blah 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 blah. And I'm just like, that is wow. I hope she doesn't actually believe that. I'm assuming she's just stupid and doesn't understand what that means.
well, yeah,
She is.
probably.
She absolutely is. Well, I mean, she brought up the Family Guy animation cartoon sex in court.
Well, first of all, it's not. There's no sex. There was no sex in the video. Second of all, it was a clip from Family Guy. There was an Asian woman holding a microphone, acting as a reporter in front of something else, but there was no sexual activity of any kind happening on the screen. It wasn't about her. And if she thinks that Family Guy is now making episodes about her life, then she needs a padded room for real, because that's fucking wild.
Yeah, well.
On top of that, Queen Bee didn't even make that video. It was Heels in the Air that had made a video and then played that clip at the end of the video. And it had nothing to do with Betty. So I don't know why she keeps bringing that up.
She also lied in her. You go. Sorry, Jimmy.
No, go ahead.
I was about to say, like the lawyer brought up, like she lied in her pleadings. She stated that she did not have sexual relations with Jonathan Lee Richards. And it turns out that she admitted not only in the police report, but also in multiple lives that was her boyfriend and that they would have to. So this shows like this goes to her character. And it's like it's a very damaging thing when the jury see this person who just plainly lied multiple times in their filings.
She's so snarky too, like with the judge, she's just so snarky and she cuts him off and everything else. She's just a rude person.
Yeah, she was constantly like over talking him and cutting him off. And it was That is not that is not advisable in court. And the other thing that I noticed too is that she really thought that she could make the actual foundation of her whole lawsuit about whether or not she had sex with these two people separately or whatever, and then say, oh, but you're not allowed to ask me any questions about it. Bitch, what? That is like, if you're going to sue somebody for something, then guess what? They have the right to do discovery on whatever it is that you're accusing them of doing. And then they have the right to ask you about it.
Yeah,
She can't just like make something up and then be like, okay, give me money, judge.
Yeah,
Right.
No, yeah. What's going to be asked is going to be like, okay, how long have you known me? And first off, it's going to go all the details of JLR and the relationship because she's brought that in her filings, everything. Then it's going to talk about Dolly and what the situation with that is, and he's going to ask all questions surrounding that, and that's just how it is. And honestly, like, guess what, lady? Transcripts are public records. What you don't quite understand, what the judge was trying to explain to you. Depositions are outside the court. It means like a private company does the typing and they get the transcript and anyone can order it. Any person on the internet can go to that court, like reporting agency and be like, hey, can I have the so-and-so transcript from so-and-so date? Now you're going to pay a boatload of money for it, but you can. Anyone, it's an open record. And that's the problem. You don't realize that all these depositions are open records.
It's the same thing when you get arrested. Your mugshot's now public record. Especially if you live in Florida, all of your criminal doings and everything on your court criminal record, that's all now public. And some, as we have found out recently in Tennessee, they're very strict, but if you live there, you can also get it. So, I mean, like the idea that somehow she's going to be able to steal this is just asinine, especially since she's the one going around accusing people of these things. Yeah. And then she thinks that people don't have the right to get the body cam footage to prove that she was lying about them, or to get sheriff's record or some other kind of record to prove their innocence, especially when you're suing the person, right? So, I mean, the idea that somehow that she can just accuse people of things and they don't have the right to, to prove that they're innocent is the entitlement just blows me away.
Which is wild is like, she doesn't sue her friend Molly Golightly. Molly Golightly was the one that started that stuff up. And also the fact is that another reason why a lot of people were thinking in terms of what's going on here is because she was fighting with Missa, which was Dolly's ex, and saying disgusting things about Missa. And it was just a very weird thing. And Missa said something on the public, and it was a big thing that was happening at that time. Now, the whole car thing was obviously the car thing was her sleeping in a car. That's what there was no concept of sexual things going on.
And Queen never said it. Nobody
never said that. No.
Right. Nobody on that panel said anything about her having sexual relations. They were laughing at the fact that she got on her channel and was laughing and telling everybody a story about how she slept in a car with Dolly. That's what everybody was talking about. She's the one that exaggerated it, lied about what people said, and then made it into a sexual thing when everybody was just laughing at the fact that she claimed that she was in the back seat snoring and he was in the front seat trying to sleep, and that he had to elbow her to make her stop snoring. That's what everybody was talking about. She's the one that made it into a sexual thing and then wants to lie and then try to sue somebody for the lie.
Yeah.
Well, that QB cannot be in her bedroom, that nobody's allowed to be in her bedroom, but she's live streaming in her bedroom 24/7 and
with her boobs out.
Yeah, she takes us into her bed every single day. So, I mean,
good point.
Yeah.
Yeah. And then with the whole JLR thing, you can't sue somebody and say, it makes me physically ill just at the thought of even dating JLR, much less doing anything more with him. And then we find out later that she's telling her police sheriff that she was dating him. And then, of course, since then, on her own channel, she has openly attacked him, calling him her ex-boyfriend. So it's like she is so caught up in the lies at this point, she can't keep up with them.
The problem is it goes to her credibility, because now, let's say she denies the whole Dolly thing, right? they're going to be like, well, you lied, Miss Griffin, you lied about JLR. Is that true? Yes. So how is the jury going to believe that you're not going to lie to the jury about this one too?
Right.
So that shoots your credibility immediately upon the jury. She doesn't quite realize the moment that she went out there and stated about JLR and their relationship was the moment that her credibility was shot. There's nothing that's going to be believed from her, because all the lawyer is going to say is, oh, so you state in your filings that you had no relationship with JLR. Yeah, well, yeah. So, and then later on the police report and also multiple live streams, here's the timestamp, here's the timestamp, here's the timestamp that was your boyfriend. Yeah. So which is a lie, Griffin? Well, are you lying now? Here, or are you lying now? You know, like then are you lying now? And are you still lying about Dolly? Are you still lying about that as well? Oh, well, she's just going to flabbergast, but she doesn't realize that she destroyed her credibility.
Absolutely. Yeah.
So when are the next court dates that she has to be there, or does she have to be there for the next one?
I'll look it up right now.
I don't know if you dropped the StreamYard thing. Obviously, you said you was opening it up or something like that.
Oh, right. Thank you for reminding me. Yes. So I will go ahead and open the panel. Thank you for reminding me.
No problem. I'm apparently the panel expert here. I got to tell you exactly how to run this panel.
While B Tim gives directions on how to run the panel, I am going to head out. I appreciate you having me. Thank you very much.
Thank you. Thank you so much for being up here.
No problem. I will talk to you guys later.
All right, you have a good one.
All right, you too. Bye.
Bye. She's probably running to get a cough drop right now.
Right? I'm sure that's hard on her.
Yeah, that's why she probably just ran to get that cough drop from the store before it closes down.
Yeah, J-Dub, the good one, because there is a J-Dubs that's a drunk, but this is the good one in my chat, who says, did you pick up on how she lied about noticing up in the last hearing? She said the attorney marked it wrong or something, but here she admits that she fucked up. That is very interesting.
No, like there's a lot of lies that woman has stated. She lied about the fact she said Queen Bee shut down my channel. No, she didn't. You have multiple. You had a copyright fight with some other guy that you stole his content on the channel from TikTok. That's why you were worried about streaming because you were worried your channel was going to jump, like be dropped. You destroyed your channel. Queen Bee had nothing to do with your channel going down. And then to like try to fight that, like I just said to myself, like either she's hiding something with that whole other channel, or she's just being a petty person. I don't know.
Right. Hey, Cheesy Weezy, what's up?
Are you the real Cheesy Weezy? We're gonna see something that's not cheesy.
No, it's me.
Okay.
I was worried about trying to come up here because B Tim said he was running the panel, and excuse me, I figured he might say no, she can't come up.
Yeah, well, she's not wearing her SpongeBob Crocs.
He's very anti-Crocs.
I'm very.
But the next dates, I'm going to just go by. I'm looking at the docket now. It says that there is a case management conference on November 15th at 10 a.m. So in the transcript, he says November 12th, but she pitched a fit. I can't make it. So he pushed it out, gave her 3 extra days. So November 15th is the next case management conference.
Yeah.
And it says in here that basically the deadline for Queen and her attorney is October 15th to respond to all motions. And Betty has until October 31st to get her reply in. And so November 15th is the next court date that I see.
And she will she's gonna drop at the last minute, literally probably a few hours past due, because she's not trying to postpone this and not go to depositions.
Right.
She's not afraid to answer questions, because the truth of the matter is that she's been lying multiple times. Her credibility is shot. Her case is over. This is like literally like it's a dying creature right now, her case, and she doesn't we just want to put the damn creature out of its misery, this case. But she wants to just hold on, cling to life, and just ignore the shit out of people for more and more time. And it's like, ma'am, you have no case. You fucked your case up, and also you might be going to jail. So you.
The Deflectionist, cool name, member for 2 months. Thank you so much. And also, since a super chat that says, y'all killed that dramatic reading. Well done, 100.
You guys did a very good job. And I imagine JP is having a heck of a time with her throat because there was a lot of words there.
Yes.
I can't imagine, mate. See, I didn't even try to do the dude voice because I'm just like, I'm just getting over COVID. So I was just like, I'm not even going to try.
She, you know, the only problem here is that she's pro se. And so the judge, I think, has a little bit of leniency with her is the problem. Because if this was an attorney screwing around like this, you know, they'd be sanctioned and everything else for wasting their client's money.
Oh, they would have been sanctioned last year.
Right, right. And so he has some leniency, which I don't think is right. They shouldn't have leniency on pro se because if you're coming up as pro se, you're telling the court that you know what you're doing, that you can defend yourself just like an attorney. That's the whole point in going pro se.
I'm kind of 50-50, and I'm going to push back only because I do think that there should be leniency because there are some people that can't afford attorneys, and so they're forced into being pro se because somebody is suing them frivolously. Like if Queen had not been able to raise the money for her attorney, she would have had to been pro se. However, I think that there should be some sort of boundary line where at a certain point, they no longer get that grace. They are now going to be held accountable for what the fuck they're doing. And I think that there should somebody somewhere should establish where that line is. And if they cross that line, they should be sanctioned the same way that, somebody else would. And I think that in her case, it's very clear, like it's obvious to everybody that she's just trying to run up the bill.
Yeah, I mean,
And,
and she fucked her case up. She completely fucked her case completely up.
Yeah.
She's destroyed it. And the fact is that it shows that she's scared of doing depositions. Like, oh, it's public. Well, yeah, because depositions are public. I'm sorry you didn't know that. I thought you were like a great fucking
legal expert.
legal. But yeah, depositions are public. I highly doubt the lawyer is going to be like immediately after the deposition, he's going to just publish it. That's not going to happen. He's probably going to, it might get out eventually, or maybe a third party might want to ante up thousands of dollars to buy it. I don't know. Someone might have my deep pockets. I don't know.
Well, the thing is she's already admitted to her relations with JLR, allegedly. Right. So we don't care anymore. She's already admitted to it. So.
Right. And we have the video of her laughing and joking about how she slept in a car with Dolly. So in fact, she said it more than once on two different live streams. Well, so she's already fucked herself.
I mean, the problem is
figuratively.
I think the JLR one was probably the biggest disaster for her because that basically shows that she lies. So basically she could say, no, I never. But they're going to be like, well, you said that for about 2 years with JLR and you denied it on multiple, and you even lied on this document that you sworn under the penalty of perjury that you never had some sort of sexual relations with JLR, and then we find out you lied. So are we going to take your word for it? Or are you a liar? Or are you lying now? Or are you lying then? I mean, we don't know when you're lying, and that just destroys your credibility. And she's just a very unlikable person. She doesn't realize she just immediately destroyed her situation there.
Texas Blue Bonnet says superfluous. Burntos, don't know if you see me. I see you. New word for Betty. Yeah, she's going to use that 50,000 times. Notice how she isn't using bode nearly as much as she used to. Ninny C says, great job, JP Toasty and Chloe's uncle.
I'm not Chloe's uncle. I disavow Chloe.
Yeah, I mean, there's just it's so I'm glad that we were able to go through this because there was so many things in this transcript that was vastly different than how she described it to her audience the morning afterwards.
Yeah, I mean, you listen to it and you realize he wasn't even entertaining it. It's like you have no evidence, you have nothing to back it up. Basically, the only reason why that the whole abusive process wasn't granted was because for some reason, I don't know. I thought she met the abusive process purpose. I guess because she's pro se, they think, okay, she's an idiot, so we got to give her some leeway. If she was an attorney, we definitely slap her with it. But to me, I feel like that should have been granted as well, because I feel like she was abusing the process.
Right. I mean, I completely agree. Somebody says I watch U.S. trials all the time, and when a defendant is pro se, the judge informs them that they are held in the same light as attorneys, therefore not given special treatment. That may be in criminal cases, but in civil cases, they are given extra leeway, especially if the pro se litigant is the plaintiff.
Yeah.
And she's the plaintiff in this. She's the one that's running around suing everybody.
And the problem is she's like, they're putting me through this. No, you're putting yourself through this. If you dropped that case a while ago, no one would ever be able to do depositions on you, Betty. That's the problem. Like, you are your own sabotage. You sabotaged yourself on this whole thing. You could have moved on, did your own thing, and instead you dragged it out. And you're still gonna. I don't even think I think November is gonna come around, and I don't even think we're gonna get to depositions still in 2025. To be honest with you, I think Brian Koberger will be convicted of murder before this case is over.
Yeah.
Like, I have this feel like 2027 we'll be doing like dramatic
Lord
readings.
have mercy.
Like, people will be like literally sitting here and be like, what the hell's going on?
I hope the judge can put a kibosh on it at some point.
I agree. Yeah, I mean,
I would think he could. I mean, there's got to be something he can do.
I mean, this judge has got to take control of the situation, because this lady is delay. It's almost 2 years out, and you haven't even done discovery yet. She hasn't even replied to the counterclaim yet. There has to be some kind of timeline where you say, we get discovery, we get depositions, we go to the case, and we get this stuff resolved. But now,
you know what's so crazy is that she is in this transcript bitching about how the counterclaim should be dismissed, even though the judge has already ruled it's not going to be dismissed. Stop filing that. You know, it's just stop doing that. But on top of that, she's trying to get something dismissed that she hasn't even responded to. Like, I don't think people, like the newer people, realize her deadline for responding to that counterclaim was December of 2023. So it is now almost a year late.
9 months.
It was supposed to be like December 8th or 9th, 2023 is when that was due. And it's now October.
So that should be forfeited then, I would think, an automatic win.
I think so.
I think if you don't respond for that long, the judge needs to sit down and be like, listen, you either respond in like 30 days or it's default judgment at that point. And we don't even.
I think at this point he shouldn't give her a chance, but I don't know what the law is in Illinois.
I don't know.
I'm not a legal expert like Betty.
Yeah, I think she's destroyed her case, and I think she's making herself look more and more foolish. And she's like, "Oh my God, I spent $1,000 to get her." Well, ante up a lot more money, because guess what? You're going to have to go there at least 3 to 4 more times, a minimum. If you get deposed and QB gets deposed, and that's a minimum just for the depositions alone. Then you have the depositions. Then you have the possibility you might have to hire an attorney for the deposition of QB.
Yes,
you got
she doesn't understand that part either.
Yeah, and then guess what? That lawyer's not going to walk in cold without having understanding the case. So he's going to be like, "I need $5,000 to $10,000 down right now," just like how you got your other lawyer, and then you're going to have to cry, I don't know, and say, "I need money," and then you're going to be deeper and deeper into a hole that you're not going to get any money from. Like, let's be real. Even if she won, which that will not happen, even if she won, you can't get blood from a stone, lady. Congratulations.
Right. Yep.
Right.
And isn't it funny how she was like, she said that Illinois was tens of thousands of miles away, and then she corrected herself, "Oh, thousands of miles." No, Betty, it's 1,000 miles.
Yeah.
10,000 miles.
Well, one thing I'm worried about, and Queen Bee, if you're listening, plug your ears for about 2 minutes. I'm worried that she's going to drag this along until the next judge gets picked, and then we're going to start all over again.
It doesn't work that way. It's already.
That's what happened the last time.
Yeah, but they're going to go
changed
forward.
Judges. Now we're starting all over again.
No, we're not starting. That was dismissed.
Well,
and now this is her second complaint.
I understand, but what I'm saying is that old judge would have probably dismissed a lot of this already, and we wouldn't have been this far. I think
Maybe
the first judge.
Maybe.
But then because it went on to another judge, now he's got to get familiar with the case and see all of her antics and everything, and now finally get pissed off and realize, oh shit, she's being an idiot. And yeah, I'm
Yeah.
worried that she's going to drag this along for another year, and that new judge is going to come, and then it's going to be the same thing again.
I don't think that's going to happen with it. Like
I
he's
hope
gonna.
not.
I think it's going to be motions. It's gonna. Honestly, I think at this point, there's going to be he's going to be like, you get shit done by this point, or I'm putting my foot down, because at the end of the day, like, the judge has time. He knows, like, cases like this should be in depositions by now. Like, they should be in depositions. That's a fact. Right now, they should have been in deposition.
I hope you're right. I hope he does that, because this is getting ridiculous.
Hey, Miss Mo, how are you?
How are you, Burnt Toast? How's everybody else? I'm pretty pissed off because what Betty constantly does that irritates me is that she keeps preaching as if she's a Christian. Maybe she is. Nobody knows anybody's relationship with God. No, I'm not claiming that. But the mere fact that she continues to bear false witness, which is basically lying constantly. She lies on Queen Bee. She lies on everybody. Sometimes she even lies on herself and tries to correct it, but it doesn't work out. It just angers me. You're worried about the deposition, but these are things that you have said. Nobody picked at you. People laughed at you because of the things you said. You talked about Dolly's funky feet in the back of the car. I mean, then you talked about JLR in the back of Chili's. And I'm pretty sure the Queen Bee's lawyer has all that stuff. I mean, why are you doing this? And then you want to know how much money she has or how much money she's getting. She wouldn't have to get money if it wasn't for you. People chose to help her because of what you did.
And that's what was really interesting to me. I'm sorry, I didn't mean to interrupt you. Go ahead.
No, go ahead. I'm sorry.
No, you made a good point, because it's real interesting how she's all up in how much Queen Bee is supposedly making or not making. And here she is all of a sudden having to get her own lawyer for her criminal charges. And she's trying to raise money. And you don't see Queen running around trying to demand that Bullhorn Betty show how much money she's given to her lawyer.
And even if she did ask, it would probably just be because she was asking her how much she got. But the bottom line is this: had you never filed a lawsuit against her, and because people love her and because everybody's had their own opinion, people felt like they wanted to help her. I mean, I didn't have much. When I was able to, I did try to help, because quite frankly, contrary to popular belief, Betty's beliefs, let's put it where it belongs, she doesn't deserve that. And you wonder why you got stuff flushing up in your pipes and all types of things are happening to you. It's because of you. It's because of who you are. See, a lot of times, even though you don't see things happening to people or things aren't happening when you want it to happen behind what they're doing, there's still things constantly happening to them. You have, what do you call it? You have protective orders. You're dealing with things with your house. And I'm not trying to wish you any bad luck, but stop. And do me the biggest favor I could ever ask anybody is stop putting God in your mess. Stop.
Yeah, I don't like that. I don't like what she does.
He has nothing to do with your mess. Anytime you're lying, stealing, whatever it is you're doing, God has nothing to do with that. And how dare her do that? That's why people think Christians are microwave Christians, why people don't believe Christians are Christians. Remember this: you don't ever know anybody's relationship with God, no matter how stupid they are. That's not nice, but you know what I'm saying. Yeah. But you don't know anybody's relationship with God. Only thing you can look for is what they do that you see. And that's how, as humans, we measure it, because you can't read anybody's mind. But I really wish you would stop bearing false witness. Stop lying. Stop saying this person did this. Stop saying you know where Chris was, or you know where this person was, or that person. You know nothing. You came onto this case 4 months later. You know nothing. All you know is what they told you. And the sad part is that everything that you know is about your pocket. And you want to lie and say Queen has affected your business. Last time I checked, you getting more business than ever.
Yeah, her channel has definitely grown since doing the Sebastian Rogers case. And for her to lie to the judge under oath in those documents and say that Queen has shut her channel down is just lie after lie after lie.
And one thing I know for certain, I know for sure, is that every time something comes up that Queen can use, if Queen doesn't catch it, somebody's going to catch it for her and make sure she can send it to her lawyer. So Betty, stop.
Well,
Matter of
no,
fact,
I don't.
not
Don't
just
stop. Don't stop. Stop snitching, but don't tell her. Don't give her good advice. What are you doing?
I don't be Tim. Trust me when I tell you, that's not nice. Okay, I'm not gonna say what I was gonna say because that's not nice. But
No.
I understand what you're saying, Big Time. Trust me, I do.
No,
But
I'm
I
saying
just
when it comes to like self-snitching for like when it comes to Queen, not with the whole.
well, guess what? I have a strange feeling she's not gonna ever stop doing that because she won't stop talking. You're not supposed to talk about Katie. You're not supposed to talk about Chris. You're not supposed. She's not supposed to talk about Sebastian. And when she goes to court with Chris, she's not supposed to talk about the baby Faith.
Oh,
But
no,
it's
she's
not
going
going
to.
to stop her
Yeah, but
because
she's
she
going.
thinks she's better.
Yeah, for that case, I think she's going to jail. I think she's probably. I think she's going to go to jail. Probably, if she keeps it up, it might be upgraded to a felony, and she might go to jail for almost a year.
B10, let me tell you something about God, which I believe you already know. A lot of times when you have a whole bunch of people wishing that something would happen to her, a lot of times God will do it a different way, but he will deal with her in his own time. See, she's hard-headed. And honestly, this might be an unpopular opinion, but I pray for her because somebody's going to hurt her at some point or another. If it does not happen on this time, I thank God for Chris and Katie that they were able to gather in the Chris's mother and his stepfather. They would gain the strength to do something because I think this is going to set a precedence in this in the true crime situation.
Well, I think you're going to get
hope so.
I think you're going to get a protective order because she's going to take that as a threat that you threatened her.
Okay, well, you know what, whatever. First of all, I don't have anything. And second of all, I don't have good sense. You really don't want to do that. But I hope she does. This ain't even I'm just tired of her hurting people or doing stuff to people that I care about.
Well,
no matter what I've said or how I felt, I care about their, yeah, baby.
Well, how do you know it's not God's plan that she goes to jail and gets a wake-up call? She says, oh my God.
Guess what? You could be 100% right. But what I'm trying to get you to understand is that sometimes God's plan is not our plan. When we think, because to be honest with you, I hope that when she goes, what is it, the 23rd? I hope that when she goes to court on the 23rd, they lock her high pops up. But that may not be in God's plan. So no, I'm just saying nobody get discouraged because there's a lot of things happening to her that we may not see. A lot of times God deals with things out of your sight, not of your view.
Well, it could be like Jonah with the whale.
It could be a whole lot of things. There are a whole lot of examples in the Bible. But I do know one thing, you're not going to keep on calling on God's name while you do your mess. She needs to stop doing that. That's not okay. You are lying to people, and we all know you lying. It's proof that you're lying. How you going to sit up there and say that you don't want anybody to be able to question you, but these are things that you said. This is not stuff that people pulling out of thin air. I'm sure Queen has sent her lawyer every single thing to prove that this lady said that. Yeah. You lied. I'm on a live, baby. Calm down for a second.
Miss Mo, you're a better person than me because, you know, some people you pray for and some people, for me, you know, some people I pray on, like let your karma, you know, let her karma have her. and she's got shit coming up out of her tub. So there's that.
Yeah, well,
So
that's not
you know,
really God punishing.
Well,
That's
guess
more
what?
like,
That's the stuff that sometimes that
hey,
God deal with
God,
people
God,
that you
God,
don't
God made
necessarily
that.
see.
That's right. God made that tree root. I'm
uh,
just saying, you
I,
know.
I, I think it was the grease that she was flushing down the sink that probably ruined her pipes. To
And
be
you
honest.
could be
Well,
right.
but
But most of it's the mess that she's been sucking down, flushing down the sink of life, lying, and creating drama. I mean, I ain't even gonna say what I think about Seth going in the courtroom with her. I'm gonna leave that right there. That
I
was
just don't have any
disturbing.
sympathy for her. I just don't have any sympathy for her. But I
I
do
have
think it was
prayed for
very.
sympathy for her, but she don't have no idea what's coming her way if she don't stop it.
I just thought it was very interesting how pressed she was about that deposition, y'all. Hmm.
Yes. Thank
She
yeah,
was
thank you
very.
for bringing that up. Yeah.
You
She was
wouldn't be
very.
talking about that old freaky stuff when nobody be able to question you.
Mm-hmm.
Everything that
And
lawyer will be able to question her on is things that she said herself. It's nothing
And
that
things that
Queen
she
made
put
up.
in her lawsuit.
Yes, ma'am.
you know
And I
those.
found it
You
very
know.
interesting. I'm sorry, Rowena, go ahead.
No, you go ahead.
I think there's like a delay or something. I'm sorry. I apologize. Um, but yeah, I was just thinking about that because she seemed above and beyond anything else. She seemed the most pressed
Yep.
about people finding out about who she's going behind Chili's with.
You know, she griped
Mm.
about, the transcripts being obtained and read, that kind of thing.
Mhm.
She's a little peeved about that, but she wants it shut down. She wants it sealed. She don't want that deposition. And it's like I said, Betty, schedule that date. If you think
But
you can get
Yes,
money,
ma'am.
schedule your date. That's all you
Well, you
got
know
to
what
do.
I think
If
that
you,
I do. You know what I think, Rowena, that you should do? During the deposition, the lawyer should order lunch, and it should be coming from Chili's. 'Cause I think Chili's delivers, and he could pay
bitch.
for Betty's
Just like
lunch.
troll her ass.
Exactly, exactly. I'd be like, bitch, you want the baby back for the Southwestern Negroes? What you want, girl?
Oh my
See, that's what
goodness.
I do.
You
See,
want
that's
hot
what I
sauce?
do.
No? Okay.
Exactly. But you don't get no margarita, baby. We working. Yeah, we're gonna keep you sober as a judge, baby. Yeah.
Well, the
But I
truth
Well,
of
just
the
thought
matter
that was
is, nobody would have known about Chili's had she not said it.
right,
exactly.
Nobody
And
would have
nobody
known
right,
about her sleeping in the car with Dolly and his feet smelling like Fritos had she not said it.
exactly.
right,
The only reason
right.
why any of us know about it is because she was talking about it on her channel.
Look,
Because
I got
she
a whole
said it.
Chili's. I got a whole Chili's enterprise going right now, y'all. Just over her words. I mean, I got Chili's covered from coast to coast.
I need to
Lord have
My
hire her.
mercy.
and look,
With
and everybody. No,
golden knee
I,
pads.
yeah, golden knee pads. But I ain't gonna hire Betty. No, I don't. I got standards, but I will say, everybody just stay calm. I know depositions cost more, but me and my Chili's girls, we got this. It's all right. It's all right. But I just thought it was very interesting the how pressed she was on getting that deposition sealed,
Very
and the
pressed.
the question. Yep, I thought that was, you know, I thought that was very interesting. But JP, if you're listening, great job. Gargle salt water.
She surely did a great
Stuck on a
job. All of them
lifesaver.
did.
BTM, burnt toast, good job. Miss Mo, good to see you. Cheesy, good to see you. I'm gonna hop back
Good
down
to
in
see you
chat.
too, Rowena.
But yeah, Chili's Girls Unite, baby. Chili's Girls Unite. Bye
Yeah.
bye. Thanks for letting
I,
me up,
Bye
Cheesy.
you
bye,
know, I
Rowena.
Bye
some
bye.
they, also like, she brings up
Bye.
Chili's, and suddenly Chili's started going, like, people started becoming popular again, which is kind of
She
crazy.
single-handedly saved the brand.
She saved the brand of Chili's. Like, they got a new menu out. Like, they got, like, what is that new breaded, like,
A
spicy.
twofer, ribs and ass at the same time.
She's gonna go on a live and say, listen,
You just said ribs and ass at the same time. Okay, I'm done.
that
Let me
was
get down.
Toasty, not me, that said that. Don't,
I
director,
know who
don't look at
said
her.
it. Yeah. Like Toasty would say, yikes. The
Uh,
bottom line is this, Betty. you bear false witness on a lot of stuff, and you say you're a Christian. You should know that that's in the Bible about bearing false witness, baby. If you don't know nothing else, you should know that. So you make your own decisions. You decide, because one thing for certain, two things for sure. Everything that you said that Queen B has lied about, she has your own voice.
Yep.
Saying it.
Now, can
So-
we discuss how the commercial would go for? Because I think she can actually become a sponsor for Chili's.
Baby
Big
Magic.
Tim, I ain't messing with you with that commercial.
So, like,
That's what I'm not gonna do.
This is the commercial I imagine. It's like she goes on the front of this. You know, guys, when I long nights sleuthing by myself in my bed and I have no one, and I really get hungry at late night, I go to Chili's and I get the twofer. And I make sure to get the twofer, but then I bring it home and I eat in my bed. And you can show like a video clip of her on the computer by herself. It's like 2:00 in the morning. She's stuffing ribs in her mouth. She's got a picture of JLR on the wall, just staring at it. While she's drinking some some Tito's or something. I don't know what they serve there as drinks or whatever.
Cheap wine.
Cheap
likes
wine.
cheap
You too
wine.
could be a web sleuth.
I've
too
been
could be a
there.
web
Cheap
sleuth.
wine. Well, at the end of the day, I hope that this turns out for Queen in the best way ever. And I hope it turns out for anybody else, because I have a strange feeling that she's not going to stop at Queen.
Oh no.
So,
She's
unless
not.
they sanction her, she's not going to stop at Queen.
I agree
But
with
Betty, this is what I asked you, and I'm going to end with this.
I agree.
If you don't know
I think
anything
she's gonna
about
stop.
bearing false witness, which I believe you clearly don't, look in the Bible under bearing false witness, because that's what you do constantly. Stop upholding other people's lives and other people's journeys so you can make a paycheck, because that's all you're doing. You're entertaining other people's lives, other people's clown show, other people's rally, so you can make money. But your days are becoming short and limited. What I really suggest you do is get some time together, get yourself a resume. You might only be able to work at McDonald's or 7-Eleven, the people you talk trash about. Or Chili's. I don't think they have it there, but I'm gonna leave that alone. But get yourself together, because your freight trading is gonna come to an end. And the fact that you're saying you're not making money, you're trying to blame that on Queen. You're making money. Stop lying on her. Stop lying on everybody. Stop lying on Bert Toes. Stop lying on whoever you can write a memo on. But stop bearing false witness more than anything. You're lying. And we may not know you're lying, even though we do. There are some things we may not know you're lying on, but guess what? God knows everything. And he knows you're lying. And if you think he's not going to deal with you, he is. So have fun. Enjoy your baby Delilah. She's amazing. But stop it. Get some help.
Yeah.
You all have a nice night. And Burnt Toast, thank you so much for allowing me up. And you all have a nice night.
Thank you for coming up here. I appreciate it.
You too. Nice chatting with you, Miss Mo.
You too, Cheesy. Bye-bye. Bye-bye, Tim.
Bye.
Y'all have a good one.
You too.
So I have an idea for a commercial. Imagine a whole football team, and then Betty sitting in the middle, and the waitress says, "So what would you like tonight?" And she says, "A platter of eggplants." Chili's, be back, Betty.
Oh my God.
Okay, so I have to get caught up for a second. Boston Nick, thank you so much. Toasty, tell B Tim I love him dearly, in all caps.
Ban that person. I don't want to see that person. Ban him for like fucking ever. Just get rid of that person.
Thanks to all of you. Thank you. I appreciate it. So what if she's so concerned because she didn't actually have a relationship with JLR? Oh, that's very interesting. Kashmir again. Ro, how are you not going to hire BHB? She's the most qualified. LOL. Yeah, there's clearly something that she doesn't want people to know about either JLR or Dolly. I don't know.
I think she she doesn't want to get into, like, there's a lot of secrets. That woman is a liar, and she has a lot of lies that she's covered up, and she doesn't want an actual lawyer to go in there, because the thing is, a lawyer is going to do like a 4 or 5 hour deposition, but based upon, I know what's going to happen. She's going to say no. She says she's going to argue. She's not going to answer questions. It's going to be like a whole day event. It's probably going to be a 2-day deposition, and then she's going to have to come back for questions that, you know, are going to be ruled upon. And it's just simple as that. They might even call, like in some states, they might even call the judge or like the clerk there or whatever, what do they call them? They might call them right in the middle of it and say, you have to answer this question. But you probably just mark it for a ruling and just wait for a ruling from the judge and just get the transcript back and go in front of the judge probably. What's up,
Yami
Yami?
Jackie was just up here. I think she lost internet or something. You can come back, Yami.
Yami.
They would have to do something like that because
Yeah, well,
I
like what's yeah, and she's gonna be forced, like she's gonna be eventually forced, like, okay, you're gonna pay for this deposition, you're gonna pay for this, you know, if you don't answer this question, and it's as simple as that.
Okay, I think that pretty much the rest of this is just them going through their opinions and stuff like that. But I do believe that Bullhorn Betty has a rude awakening coming. But we'll see what happens. You know, and of course we've got those court dates coming up in Tennessee too. So we'll see. But you know, this was I thought this was kind of funny, and the way they were, you know, reenacting the court and stuff, you know, it was pretty interesting. A little different than what we usually see. So I figured I'd share. But yeah. All right, dear. Well, I'm gonna get back to work. Y'all have a wonderful day. And thanks for joining. Don't forget to hit the like button. Thanks a million. See you soon. Here's the outro.